ahead and introduce the facilitators for today's webinar, Denny DeSantis and David Glazerman, aka the Bursar brothers. Denny DeSantis is the Associate Vice Chancellor at the University of Pittsburgh, and David Glazerman is the Assistant Vice President and the Bursar at Temple University. So with that being said, guys, I'll turn the floor over to you.
Great, thanks, Steve. This is Denny DeSantis, and welcome to our second webinar. There are two others, so you may want to check your email in future months. Our third webinar is going to be held on September 27th, and our fourth on December 6th. So since you're registered for this one, please register for the other two. If you do, you will be automatically entered into a drawing that we will raffle a book that David Glazerman and I published a few years ago, focusing on tuition and loan receivables. So we'll have a couple copies available, and we'll see what happens in early December, right, David?
Absolutely, Denny. Good morning in the West and good afternoon in the rest of the country. Today, again, we're managing student accounts and loans for that drawing in December. You do have to be registered for the next two webinars as well. September 27th, we'll be talking about asking tough questions and some of the issues you'll need to talk about in the collection process. And then December 6th, we'll be doing an accounts receivable panel, looking at general issues on AR and giving you a chance to put all those questions you've always wanted to ask about collecting accounts receivable to the panel of experts. Today's session on legal issues impacting educational debt collectors. I want to introduce our other panelists today. Wendy Badger is a nationally acclaimed authority on the Fair Debt Collection Practices Act, Fair Credit Reporting Act, the Health Insurance Portability and Accountability Act, Bramlage-Bliley, and also their implementing regulations. Wendy gives frequent lectures and conducts training on both local and national levels to the credit collection industry. She's published numerous articles in various collection industry publications. In both 2007 and 2011, Wendy was recognized as one of the most influential collection professionals by Collection Advisor magazine. In 2011, she was one of the 3 inaugural recipients of the ACA International Members Attorney Program designation. Wendy currently serves as the Director of Corporate Compliance for ECMC Group, a nonprofit corporation providing services in support of higher education finance. Also with us today, Michael Strachan is the Compliance Officer and General Counsel for Enterprise Recovery Systems. Michael has served as the Compliance Officer for 12 years at an ERS-affiliated national collection agency. In addition to his legal and compliance experience in the industry, he brings practical experience as a result of his previous work in many facets of the industry, including working the mailroom, file room, data processing, and as a collector for a national agency. Michael's also a member of ACA International's Member Attorney Program. Just one other thing before I turn the program over to Wendy, and on behalf of the presenters, just to let you know that the information today is not intended to be legal advice and may not be used as legal advice. Legal advice must be tailored to the specific circumstances of each case, so that every effort's been made today to assure the information is up to date as of the webinar. It's not intended to be a full and exhaustive explanation of the law in any area, nor should it be replacing the advice of your own legal counsel. And the views and opinions expressed today by the presenters are those of the 3 presenters, not of ECMC Group, Enterprise Recovery Systems, their affiliates or subsidiaries, or Temple University. I'd like to turn this over to Wendy for the first part of the presentation.
Thanks, David, and thanks to ERS for having me with you today. I thought we'd start off a little bit talking a little bit about some complaints and lawsuits that have been plaguing the credit and collection industry lately. And over the last couple of years, both the Federal Trade Commission and the new Consumer Financial Protection Bureau have received lots and lots of complaints about debt collection practices in general. And they haven't really differentiated between what are considered first-party and what are considered third-party complaints. So in 2010, as you can see, they received just under 110,000 debt collection complaints. That number went up in 2011 to over 117,000 complaints. And that number represents just over 22% of all of the complaints that at the Federal Trade Commission they received in all of the areas they cover. So everything from consumer protection to antitrust issues, anything that in advertising, anything that the Federal Trade Commission covers, 22% of all of their complaints were related to debt collection practices, specifically under the Fair Debt Collection Practices Act. We're also seeing, in terms of lawsuits, we're seeing trends increasing there as well. According to the website fdcpacases.org, in 2011, there were over 11,000 lawsuits filed in federal court under the Fair Debt Collection Practices Act. That number represents a 10% increase over what we saw in 2010, so we're definitely increasing. Through this year so far, through the end of May, we've seen just over 4,000 federal lawsuits filed under the Fair Debt Collection Practices Act. Now, if we compare that to the numbers that we saw through the end of May in 2011, we're actually at a decrease. We're at about, last year at the same time, we were at 4,299 lawsuits filed as of May 31st, 2011. So that's actually a difference, or a decrease rather, of 4.6% of what we saw. I've got a couple of theories that I'll share with you about why we're seeing a small decrease in those numbers. But keep in mind that this represents only lawsuits that have been actually filed in federal court. It does not include any kind of pre-litigation demands or state court filings at all. It had to have actually been filed in federal court. So I think that's part of why we've seen a small decrease this year, is that folks have taken to sending a pre-litigation demand rather than moving forward with filing suit right away. Some other numbers that I just wanted to share with you briefly before we get to talking in a little bit more detail about the Consumer Financial Protection Bureau is we're also seeing some staggering increases in litigation related to the Fair Credit Reporting Act and the Telephone Consumer Protection Act. And I wanted to bring those up specifically because those relate across the board, not just to third-party debt collection professionals. The Fair Credit Reporting Act, if you are a data furnisher, providing information regarding your students, your borrowers, to any kind of credit bureau, consumer reporting agency, that's going to impact you. The Telephone Consumer Protection Act, if you're making any kind of phone calls with using auto-dialing equipment, if you are using any kind of, if you're sending text messages to consumers, if you are pulsing anything out on caller ID, the Truth in Caller ID Act also falls under the Telephone Consumer Protection Act. And what we're seeing there is some huge increases. As of May 31st of 2011, so just a year ago, we saw Fair Credit Reporting Act cases at 489 lawsuits actually filed in federal court. As of May 31st of this year, we are at 857. That is a 75% increase just in that time frame. The numbers for Telephone Consumer Protection Act, TCPA cases, are even more concerning. This year, or last year rather, at this time, as of May 31st, 2011, we saw 198 lawsuits filed under the TCPA. As of May 31st, 2012, so just a couple weeks ago, that number was at 383. That is a 93% increase in Telephone Consumer Protection Act lawsuits that we're seeing. And again, that doesn't count for if we're getting any kind of pre-litigation demand or filings in state court. So those numbers are just the tip of the iceberg. And in fact, in May alone, if we compare the numbers just for May 2011 and May 2012, it's astronomical. It is 223% increase just if we look at the month of May and compare 2012 to 2011. So the litigation is definitely not on the decrease. Part of what we're seeing also is the new Consumer Financial Protection Bureau. They went into full effect about a year ago, in July of 2011, and they have been working pretty much nonstop. And what they've been doing specifically as it relates to student loans is they've created all sorts of information. They have a very specific section on their website, which is consumerfinance.gov, G-O-V. They have their student loan know before you owe section of their website, and this includes all sorts of information, what they're calling their financial aid shopping sheet, which discusses different costs of college, different loans that folks could be eligible for, work-study programs, what monthly payment estimates are going to be for after graduation. And what we're finding, or what they rather are finding, is that many students think of their post-graduation salary or what their salary expectations are. They look at that in terms of gross terms, what's their gross salary, not what their actual take-home pay would be after taxes, after all of the deductions have been taken, any 401k contributions. They're looking at their gross salary and not their take-home pay. So if they're calculating what they might owe on a student loan, for example, on a monthly basis, many of them are thinking that they should be able to afford it based on their salary estimates for their chosen field or their chosen profession based off of their gross pay, not their take-home pay. The CFPB does have a student debt repayment assistance section on their website as well, and a financial aid comparison shopper. Now these are fairly interesting. These include the ability for users of the website to go in and rank features of items that are included in their financial aid shopping sheet to see what do they think is the most important information for a student or a recent graduate to have. And this would include everything from their ability to repay their loans, comparisons to what others at that school are paying for what they pay, what the average student would be paying, what others at the school have been able to repay, what is their expected debt going to be versus the national average, and a breakdown of cost at the school broken down by category, so broken down by books, broken down by food plan, by their room and board, by tuition, all of those different factors that go into it. And actually, the CFPB is currently looking for feedback on these portions of their website. That feedback, they're looking to cut that off as of June 20th. So there's still time to go in there and submit comments right on their website to the CFPB. One thing that we recently saw is not too long ago, the CFPB opened up their private student loan complaint submission section of their website. And in the past few months, I want to say that happened, I think it was in the end of February that happened, or early March. The CFPB has received more than 2,000 comments from student loan borrowers, from higher education organizations, other nonprofit lenders, as well as banks. And they just recently, within the last day or so, made that information available through their website as well. So that's interesting to note, and they primarily are focusing on private student loans, so not necessarily government student loans, but what the CFPB is thinking is that a lot of the information that they're getting through their complaints can be extrapolated on a much larger scale outside of private student loans. The CFPB also has its very own student loan ombudsman function. They have there's all sorts of information available about the ombudsman, what their function is, what they're looking to do, how they are looking to help. And certainly one of the things that they are looking to do is, it's their job to sort of informally resolve issues with an organization in what they consider an independent, impartial, and confidential way, and really looking to advocate more for a fair process rather than on behalf of the borrower. They do look to keep information confidential unless they get the borrower's consent to be able to share the information, or if the law would require that it be shared, or if the CFPB Ombudsman Office has a concern that there's a threat of imminent risk or serious harm, or that an issue has been raised of government fraud, government waste, or some other type of abuse. Like I said, there's all sorts of information on the CFPB's website about their ombudsman function. And one thing that they have acknowledged is that as they look to implement regulations in the private student loan world, they've acknowledged that any new regulations that they come up with or submit for notice and comment might not help borrowers now. It would really be more towards the future. So they're really looking to take information that they're getting from borrowers now, folks who are either about to enter repayment or who are in repayment. They're looking for those folks to help guide them as they develop these new regulations. The student debt repayment assistant that the CFPB has is really quite interesting. It walks you through a whole host of questions, everything from what type of loan do you have? Do you have federal government loans? Do you have private loans? Do you have both? Whether the borrower or the user of this tool thinks they can pay in full. Information about whether or not they are a military borrower, because different options might be available there. Information on, they provide links to and information about the NSLDS to make sure that the borrower has all of the information on all of their loans as they're using this tool. But primarily this tool really directs the borrower back to contact their servicer, to ask questions about graduated payments, extended payments, forbearance, deferment. It provides information about income-based repayment. It actually includes an IBR calculator and an IBR fact sheet, as well as guidelines based on their income as well as their family size to see whether or not they might be eligible for some type of income-based repayment. What's interesting, though, is that I think by and large, people either don't know that this exists or just aren't using it or just don't know about it. So I don't think it's been used very much other than by folks in the industry already who know it's out there and who are providing comments on the different tools available through the CFPB. And they've recently indicated that they'll be taking some enforcement actions as well. So that'll be something to keep our eyes open for. With that, I'll turn it over to David to talk a little bit more about how colleges and universities are affected. David?
Thank you, Wendy. Just to follow up on what you're saying, CFPB is working very, very closely with the Departments of Education and Treasury in coordinating their efforts. A lot of the discussions related to the IBR, ICR content came up in the recent negotiated rulemaking session. Some of the changes that are going to be promulgated through regulations over the next few months are really, I believe, have been in consult with CFPB. The fact that they've gotten 2,000 plus submissions in a very short period of time also tells me that's just the tip of the iceberg. Again, the knowledge base about this is growing. I think you're going to see many more initiatives out of the federal agencies to promote these sites. You're going to start seeing it more in the general media. I think to this point, Wendy, you're correct in saying it's pretty much been limited to the industry, but more and more you're starting to see this in general media, since the whole topic of student loan debt and tuition costs for college and universities is becoming a mainstream issue. In general,
it's becoming an election issue too, David, with the upcoming election and interest rates. That's been quite the stand that folks have been taking on the political front as well, so we'll definitely be hearing more about it.
I think you're right there in the sense that, especially with June 30 being the cutoff on interest rates for the federal programs and how that's going to be paid for, that again, I think is the tip of the iceberg. You're going to see this throughout the presidential campaign. You're probably going to start hearing about this as well, even in some of the House and Senate races. You're going, advocates, I think, will come to the forefront and start talking about it, because this is where, we talked about mortgage debt for a long time. Credit card debt now ranks below student loan debt, so it's, again, very much mainstream at this point. You're hearing a lot more discussion about it in the general media. For the colleges and universities, I think there are a couple of other factors. We talked about the volume of complaints and lawsuits. I think we're all used to getting complaints from our president's offices and with senior leadership about how collection agencies are, and I'll use the term allegation because it really is. When you talk about how people perceive third-party agencies, it's always a tactic, and I believe it's a stall tactic quite often, to say that a collection agency is harassing me to avoid paying a debt. What I believe we're now seeing more of, and I know many institutions have found the complaints about collection firms are growing as a tactic. I think the economy's partially had something to do with that uptick in complaints. More so, though, the threats of litigation. Twofold tactic that I'm seeing. One is the concept of having debts forgiven. If you make the threat, many institutions, rather than try and pursue the collection, are just going to write that debt off and forgive it. The other side of what we're seeing, and again, third party, I'm going to ask Wendy and Michael to comment on this in just a second, but I think we're seeing the pre-litigation process as a means to settle accounts, and not just to have a debt forgiven, but you know what? My client has had anguish, stress, etc. That's worth a few dollars right there. I think what we've seen in the last couple of years, that tactic, and by the percentage growth in actual litigation, because we're, again, being the tip of the iceberg, a lot of cases are settled so as not to have to deal with the expense of litigation. So you've got debt forgiveness coming into play. You have the concept of settlement rather than having to go through the litigation process, which can be very, very expensive for an institution. But I think the key fact that you need to know, we're seeing more and more cases. It's not just the third party that's being threatened with this litigation. Our colleges and universities, their clients, are also facing that same threat. And again, I think it's very important, an education process on your campuses. It's one thing to get complaints. It's another thing to have to get through the legal system and have to defend them in court. So be aware, it's there right now. We've seen it firsthand. You have to understand that this is a new tactic, but it's happening more and more today. That's why it's also important when we have situations where our agencies are asking for information. If a consumer disputes the validity of a debt, we really on the campus need to react to that very quickly. There are issues around Fair Debt Collection Practices Act with fair credit reporting that we need to have responses made within set time periods. And failure to do that can have consequences both to the ability to collect that debt and potentially leading down the road to other litigation. So in terms of acting quickly, even though maybe in the middle of fall registration we may have hundreds of students we're having to deal with, there needs to be a quick reaction to these informational requests.
David, I can make a couple points to the first comment about what we see driving litigation, certainly from the agency side. One other category I would add is that there's a growing number of lawyers that are just dedicated to suing over debt. And as those players increase in the market, we continue to see the same lawyers over and over again. And I literally think one of the drivers for the explosion in litigation is there's firms that are dedicating their resources to suing agencies, and now I think they realize by including the creditor, whether that's a bank or an institution or university, that it increases leverage, it increases value of the case, and to the extent that the borrower gets benefit out of it from the standpoint of a debt's forgiven or a better settlement, I'm not always sure that's the lawyer's first concern, and maybe that's not a nice thing to say, but we definitely see the increase in litigation from a few of the same players, and I suspect Wendy could comment on that and see the same thing. The other point I wanted to comment on, where you're saying it's important to get these documents to the agencies. Too often I think that the right people aren't in the room when the conversation's going on, which I think these webinars are just a great idea to get lenders and creditors involved in the process, because the reason we're seeing a lot of regulation that we're seeing, I think, stems to a certain degree from a growing frustration, and understandable frustration on the part of borrowers in all industries and debt buyers, where the debts get sold and the information that goes from a lender to a buyer ultimately winds up being a spreadsheet with a name and a number. And I understand why people are frustrated that they're getting calls about something they don't know about, they don't have enough information. And on the agency side, that information enables us to go back to a borrower, give them what they want, answer their questions, and help collect the money. It's not enough simply to say, hey, we verified your debt, your name, you owe this money. That might be all you're entitled to, but without some paperwork or something demonstrates their payments or addresses their disputes, it doesn't help collect the money. Even if you're complying with the law, sort of the letter of the law, and getting information to them, without something meaningful that responds to their dispute, you're not going to collect money. And again, every time I go to a lot of the conferences or FTC roundtables, it seems like the people that aren't in the room that really need to be are the creditors and the lenders, because that's where the conversation seems to start in terms of documentation. And that's more than kind of what you were commenting on, but I wanted to add that.
Okay. Let's move on to our next section. We want to talk now about adding collection costs to accounts. I'm going to turn this back over to Wendy.
Thanks, David. And Michael, excellent points, very well made. I couldn't have said it better myself. I've got nothing to add to that. So let's talk about collection costs. Under the Fair Debt Collection Practices Act, from a third-party collection agency's perspective, an agency cannot add collection costs to an account unless collection costs are either expressly authorized by the agreement that creates the debt, or those collection costs are permitted by law. The Fair Debt Collection Practices Act prohibits falsely representing the character, amount, or legal status of the debt. And so if collection costs are added inappropriately, if they're not authorized by the agreement or they're not permitted by the law, and those collection costs are added, the collection agency has then misrepresented the amount of the debt and could be subject to a lawsuit or claims related to the FDCPA. And this is one of the areas where we're seeing the creditor, whether that be the college, the university, a credit card company, what have you, we're seeing them pulled into these lawsuits by either requiring that the collection agency add collection fees or adding those collection fees before that account even gets placed. We're starting to see that happen in those lawsuits, in those pre-litigation demands, that a pre-litigation demand will go to both the creditor and to the collection agency and say, hey, somebody screwed up. We don't care who, but someone's going to pay us. So we're seeing that. And there's also, of course, then enter the state law factor as well. Some states have prohibitions and limitations on whether and when you can add collection costs. There are some states that specifically do allow it, so it is permitted by law, and there's other states that completely prohibit it. And I believe as part of this seminar, we had a couple of additional handouts as well that if they haven't been sent out already, we'll make sure to get those sent out that address this in a little bit more detail. Now, more specifically related to student loans, some of the state law restrictions are trumped by the Department of Regulation, the Department of Education regulations, if we're talking about federal government student loans. Those state law restrictions and prohibitions will be preempted or trumped by the department's regs. But some states do have statutes that specifically address adding collection costs to student loan and educational debts, or that would impact the ability to be able to add collection costs to non-federal student loans. So you want to make sure you review your state laws carefully, because those statutes may be applicable in certain limited circumstances, such as if the debt is owed to a public institution and therefore owed to the state. But if we limit ourselves for just a minute to federal student loans, the Higher Education Act and its regulations specifically do allow reasonable collection costs to be added to an account. Of course, we've got some promissory note considerations as well to provide proof of the borrower's indebtedness and that notify the borrower that, hey, we're going to add cost of collection if we have to, if this goes delinquent, if it goes into default and we have to take those types of steps and bring in somebody else, we're going to add our cost of collection to this. And then typically that promissory note is going to include that borrower's signature, so it shows that even if they didn't read it, they should have, and they agreed to everything that's in that note. So under the Higher Education Act, reasonable collection costs are determined on actually a cost averaging basis that considers the total cost associated with, for example, a guarantee agency's entire portfolio of defaulted student loans, as opposed to requiring the guarantee agency to specifically track individual charges that are associated with the collection of a particular account. So, and oftentimes these regulations too will say, you can add 18.5% as a collection cost. It's going to provide some limitation. So some important factors then to keep in mind, sort of the do's and don'ts, if you will, of adding collection costs. Make sure that you calculate the amounts carefully, particularly if it's regulated by some of those student loan regulations under the Higher Education Act. If there's a specific percentage, make sure you abide by that. What's also important is to be able to, whether the institution or the collection agency, have the ability to itemize those amounts out. There are some states, for example, the state of Washington, that will require more specific itemization of what's interest, what is a collection cost. They'll be able to make you be able to break that out. And then applying payments correctly as well. Under the Fair Debt Collection Practices Act, it's important to recognize that if a borrower, if a consumer disputes a debt, you cannot apply a payment to the disputed portion of a debt. So the borrower may be disputing late charges, collection costs, or the interest, and then that payment cannot be applied to that piece. So that's also why it's important to be able to have that ability to itemize out what's made up this total balance due, so that we can appropriately apply those payments. In addition, a consumer can provide specific instruction that they want a particular payment to go directly to the principal balance, that they don't want that payment to apply to collection costs or interest. They want it to go directly to drive down the principal balance of that account, and they have the ability to do that. And so make sure that your systems, and you work well with collection agencies to make sure that you've got the ability to be able to do that. Some collection costs don'ts or do not add amounts beyond what is allowed. As I mentioned, particularly with consolidation, at least at my company with ECMC, we're starting to see some folks want to consolidate all of their loans together. In that instance, you're limited. Collection costs can only be up to 18.5% for certain consolidations. So you want to make sure that you're only adding what is actually allowed. Make sure that, as David mentioned, you are not ignoring borrower inquiries and disputes. Have this be somewhat of an open process so that they know what's being added, how it's being added, and how you calculated that amount due. And of course, by ignoring the inquiries and the disputes, we run into all sorts of problems under not only the Fair Debt Collection Practices Act, but certainly under the Fair Credit Reporting Act, when you've got a certain amount of time to respond to a dispute, as well as mark an account as disputed if it's been credit reported. And as we know, once these accounts go delinquent or fall into default, their credit reporting is going to be required. So we want to make sure that we're not ignoring those types of inquiries and disputes from the borrowers. And we want to be transparent in this process, not hiding costs as a miscellaneous fee. Call it what it is. If it's a late fee because the payment was late, call it a late fee. If you're adding that 18.5% or whatever the percentage is, call it just that. It's your collection cost. Remember, as I just mentioned, under the Higher Education Act, it can be determined on that cost averaging basis. So you don't have to necessarily prove that all of those collection costs were incurred with respect to that debt. It can be averaged out. If it's an interest charge, let them know that that's what interest is and what their principal balance is. The more transparent we are in this process, at least it's been my experience, that the less likely the borrower is to dispute the entire balance. So at least then we're able to focus on, let's get the principal paid down, and we can figure out what the issues are with either the late charges or the interest or what have you. So those are some of what I've noticed as some of the do's and don'ts of adding collection costs. David?
Thank you, Wendy. We'll go to the next slide. But before I talk about what schools should consider here, I just want to remind everybody, if you have any questions, you can submit them directly through the Q&A box or through the chat box on your screen. I also want to mention, too, in terms of the Perkins Loan Program, for specific information in Section 674 of federal regulations, information that you may need regarding the addition of collection costs on Perkins debt. I want to focus for a minute, though, on institutional accounts here, and primarily tuition and fees, and some things to consider if you're looking to add collection costs. First of all, I think it's important, what is your institutional philosophy? If you're if you find there's a lot of resistance, if you consider potential publicity risk of being known that you're doing something like this and it's not perceived well in your community, if there's no commitment to follow through, if you're putting this on strictly as a means to leverage getting partial payment and using this as a waiver tool, that may not be in your best interest, and that becomes known at some point in time. So understanding how your senior leadership feels about adding costs, as our budgets get tighter, there's more discussion about taking these steps, but if you don't have that commitment from the top down and you're not supported, likely you're going to have situations where you're either succumbing to pressures from your borrowers and students, or you're just not going to be able to implement at all. Look at whether right now you're committing your debts into a promissory note, or if you have some type of a financial responsibility statement at the beginning of your registration process. If you've committed to either of these steps, and again, I think transparency is important and the clarity of the statement is important. If you do not pay, you are responsible for collection costs. And again, it's not, I think, as specific as you possibly can as it relates to in your state law and what you're able to do. At least my experience has been, if that's not clear, if you use the term all costs, potentially, if you're in litigation, if you're taking that case to litigation, judge may rule that's excessive. I'll let the attorneys comment specifically, but I think the clearer you are on what that cost is, and the clearer you are in your prom note or in your financial responsibility statements, you're not going to get as much pushback when you assess these costs. Strongly suggest, make sure you've talked with your institutional attorney, because final question, what's your state law on collection costs? What do you need to be aware of before you implement a process or assess collection costs? And again, they're so different from state to state that we could try and talk about what those fees would look like. We would probably be here for the next 3 hours, and you would probably be very confused. It's so specific to your own jurisdiction that it's important you go back and work with your house counsel to understand how collection costs if they can be assessed, how they should be assessed, what limitations you have. So your attorney is really a key partner in going down this road.
Yeah, David, I think you're spot on. It's really a local issue to the extent the federal regs wouldn't apply. It's a local issue, and one size fits all is not a good approach.
And again, I just wanted to mention, in the email that you received, the WebEx information that you sign into this webinar, we do have 2 files for you with additional information. If you haven't already, you can download for your purposes. The next area we'd like to cover, you may or may not be familiar with. I know third-party agencies have had a lot of conflict in how to manage this process. So Wendy, I'd like to have you talk about the FODI conundrum and just explain what that is and what the impact is on our third-party agencies.
Sure, thanks, David. We're really switching gears here now. But generally, under the Fair Debt Collection Practices Act, there's sort of 2 principles that we want to comply with. One is no third-party disclosure to an unauthorized person. So you don't want to disclose any information about a debt or the fact that a person has a debt to anyone with whom the borrower, with whom the consumer has not authorized you to speak. So that sort of put that on the one side. Now on the other side is anytime you engage in a communication, you have to provide meaningful disclosure of who you are and why you're calling. And that would include what we have come to call the mini Miranda disclosure, which is that the communication is from a debt collector and any information obtained will be used for that purpose. So we've got these 2 principles with which we as third-party debt collectors need to comply. So then we enter, and remember as well that the Fair Debt Collection Practices Act became law in 1978. So this was long before the time of answering machines, voicemail, cell phones, fax machines, all this fancy new fandangled technology that we have nowadays. So now we have the situation where we try and contact a consumer or a borrower, and we get voicemail or we get an answering machine. So what are we supposed to do? Well, there was a case out of New York in, I believe it was probably 2006. Michael, correct me if I'm wrong, but I think it was 2006, where the borrower's name was Mr. Foti. I think it was like Paul Foti or something like that. And there was a voicemail message on his answering machine that said, this message is for Paul Foti. This is the name of the collection agency calling. Please call us back for an important business matter, and here's our phone number. And the name of that collection agency did not necessarily disclose that it was a debt collector. So this guy sued the collection agency and said, hey, you communicated with me in an attempt to collect a debt, but did not provide meaningful disclosure of who you were or why you were calling. Well, the collection agency said, no, we can't provide you with all of those disclosures in a voicemail because someone who's not you might be listening to your voicemail or to your answering machine. So there's this inherent conflict with this unauthorized third-party disclosure provision, and really voicemail messages are not communications as they're defined as under the Fair Debt Collection Practices Act, which is communicating or disclosing, conveying information regarding a debt through any medium. Well, we didn't convey information regarding the debt, therefore it's not a communication, so we were not required to provide meaningful disclosure. Well, the court disagreed. The court said, nope, you're wrong. This voicemail message was in fact a communication that does require you to provide meaningful disclosure as well as this mini Miranda disclosure requirement. So you have to say who you are and why you're calling, which would include either that the communications from a debt collector or that that the purpose of the call is an attempt to collect a debt and any information obtained will be used for that purpose. So we've got sort of this, it's been called all sorts of things, a catch-22, Hobson's choice, Morton's fork. You pick your cliche. We've got a problem here because if we leave a voicemail that discloses all this information, someone who's not the borrower might hear it. If we don't leave that information, then we could get sued for not leaving the information. So what do we do? Well, ACA International, which is a trade association for credit and collection professionals, has come up with a sample message to be left on an answering machine, assuming at this point that a third-party debt collector even wants to leave a voicemail message now. And this voicemail message, which if you say it fairly quickly, is going to take you about 45 seconds to leave. Well, I'm not going to even listen to my voicemail that long. If that's my mother calling me, I've already hung up and called her back. Just tell me to call you back. I don't want to sit there and listen to my voicemail. That's just my own personal take on it. But so this ACA sample message starts off with, this is a message for Joe Consumer. If this is not Joe Consumer, please hang up or stop listening to this message. And then you pause. And then you get back into it. Again, this message is for Joe Consumer. This is ABC Collection Agency calling. This is an attempt to collect a debt, and any information obtained will be used for that purpose. Please call us back at 1-800 number. So there's all sorts of other types of sample messages, but that's the one that the trade association has said, look, we think that this is going to be the safest one for you because A, it does provide all of the disclosure requirements that the courts apparently seem to think that you should include, and it also gives a warning that, hey, don't listen to this message if you're not the person that we're looking for, and if you are the person that we're looking for, don't listen to this message when other people are around because we're going to give you some private and confidential information. So there are some agencies that have decided that they're just not going to be leaving messages at all and have resorted to just whatever footprint they leave on caller ID or just trying to get in touch with a live person rather than leaving any kind of a voicemail message. There was a new decision just within the last roughly month and a half where a collection agency took a completely different approach. And they left a message that actually did not include anything that says this message is for Joe Consumer. The only thing the message said was, we have an important message from ABC Collection Agency. This is a call from a debt collector. Please call us at 866 and then the phone number. So it did not identify who it was they were calling for. So there really couldn't be a third-party disclosure because they didn't say, hey, this message is for Joe Consumer, and by the way, we're a debt collector. It just says that we have an important message, call us back, and we're a debt collector. And the court said, yep, this is okay. But keep in mind that this was a Minnesota decision, and so in Minnesota, in a subsequent communication after you've already talked to the debtor or to the consumer, all you would have to disclose is that the communication's from a debt collector. You wouldn't have to disclose much more than that. Now, there are some states that would require you to provide, or would require a third-party debt collector, rather, to provide a much longer disclosure, that this is a communication, is an attempt to collect a debt, any information obtained will be used for that purpose. A much, much longer disclosure would be required in some states, and, for example, New York City, Texas, and a few other places that would require that. But the court said that this is okay because it did not identify who the message was for and would require somebody to call back to find out more information. So you really haven't disclosed any specifics about the debt. Now, how far this decision is going to stretch, I don't know about that. And like I said, it's just a district court decision in Minnesota. So far, I don't think it's been appealed, and I do think that their 30-day time to appeal has already expired. So I don't think it's going to be appealed, but for whatever precedential value it's worth, I think that still remains to be seen. Michael, do you have anything to add to that FODE conundrum?
No, I think you covered it. Really, right now, I think it's up in the air. I think that Minnesota decision is helpful, and I think you mentioned there's a few others out there that are helpful, but really until there's something that's from a higher court, or I know that, I want to say Barney Frank has introduced a bill in Congress that likely won't pass that looks to shield collectors from liability on this issue with a sort of a safe harbor message that the CFPB could put together at some point. And my understanding, though, is that the chances of that passing are probably not good, at least this time around. There's not a lot of political support, obviously, for agencies because not too many folks get elected to Congress, stomping that they're going to help collection agencies clean up some some technology issues. So, but other than that, I think you're right. It's just sort of something to be very careful about for agencies.
Yeah, you raised a really good point, Michael, that I wanted to mention, in that one thing that the courts have fairly consistently said when dealing with this issue is that there's no inherent right in the Fair Debt Collection Practices Act for a collection agency to even leave a voicemail message. So you're asking for something that's not necessarily a right. So who says you can do that or that you should be doing that? Even the Federal Trade Commission, before the CFPB took over, the Federal Trade Commission refused to issue any kind of an advisory opinion on this issue. They said, you know what, the courts are handling this, we're out. We're done, we're out. There was one court in, I think it was Oklahoma, that said a voicemail message is not a communication and does not require any kind of meaningful disclosure, so that a very generic message would be okay. Not many courts, that's really pretty much the minority. I think there's only been one or two decisions like that. The vast majority of court decisions have said, yes, this is a communication. Yes, you do need to provide all of these disclosures. Yes, we understand that there's this conflict, but basically tough. And Barney Frank's legislation basically proposes to include a right, if you will, for a collection agency to leave a message and then defers to the Consumer Financial Protection Bureau to draft, or to craft rather, what would an acceptable voicemail message be so that we could have that kind of safe harbor. But as you probably know, Barney Frank is retiring. He's not seeking re-election in this year's election cycle. So if there doesn't get to be any movement on that fairly soon, it's not likely to go anywhere. And certainly, I doubt certainly will go anywhere during the lame duck session after the elections. Aside from that, as Michael made the point quite well, that collection agencies are not a popular soapbox on which to stand. They're not a popular group to support, particularly during an election year, especially if we're looking to give them quote unquote more rights than it's perceived that they already have. So
Wendy?
The difference, yeah, David, I just saw that we've got a question in the Q&A about this FODI conundrum. And so I'll just briefly respond to that because I really would like to get into some of Michael's comments on the cell phones and auto dialer points. But this FODI issue arose out of the Fair Debt Collection Practices Act, which applies to third-party debt collectors. So it's really not so much an issue for first party unless your collection efforts as a first party are being conducted in a different name than the first party. So it would look like to the borrower, to the consumer, that it's some other party who's involved. At that point, they might try and throw the Fair Debt Collection Practices Act at you, but primarily this is a third-party collection agency issue, and we bring it up here because this is really impacting how collection agencies are penetrating their portfolios. Are they leaving messages? Are they not leaving messages? What kind of response are they getting based on the messages that are being left or the lack of messages that are being left? It's really become quite an issue, and collection agencies have taken wildly different approaches to this. I know agencies that have completely stopped using voicemail messages at all, and they've not seen any kind of a decrease in their return phone calls. Whereas other agencies have tried that approach and they've seen the exact opposite. Their calls back have completely tanked. I've seen folks who have started using this ACA sample message and they get 0 calls back because you know exactly why that person is calling you. They're going to try and collect money that I don't have, or whatever is going through that consumer's mind. So that's why we bring this up, that it is a big issue for third-party debt collectors, and so what can or should we be doing to help them along with that? Making sure that we've got certainly valid phone numbers and up-to-date information is certainly a step in that right direction. David and Michael, I'll turn it back over to you to add any additional comments and move into cell phones and auto dialers.
Thanks, Wendy. One thing for Debbie's question, I would caution, we haven't talked about FERPA and the Family Right to Privacy Act. I think that really comes into play for what we do in the higher education community. You still have to be careful in terms of any FERPA disclosures that you might make, and I would definitely be looking to see that you have a FERPA waiver from your student before you go down this road. not the ODI, I don't think, from a first-party perspective, is as much the concern as you would have with FERPA. So same types of cautions in there. It doesn't necessarily stop you, but I think you just have to be careful in what your response looks like. We wanted to talk about, we alluded to the fact that technology is far, far ahead of the law in many cases. And Mike's going to talk about some of the uses of technology in the collection process, what we can and can't do, and what we should and shouldn't do. Michael?
Great. Thank you, David. I'm going to talk about what we're characterizing as technology issues, and David makes a good point when he says that technology is always in front of the law. And really, when you think about the Fair Debt Collection Practices Act in the late 70s coming around, I used to think that, you know, if you had a cell phone in the late 70s, it was the Motorola Brick, sort of that gray one with the black antenna. But turns out that didn't even come around to the early 80s. So if you had a cell phone in the late 70s, it was probably one that was stuck in your car or maybe your dad's car. I'm going to break my part of this presentation down into three areas. I want to talk about cell phones and auto dialers. I want to talk about emails and texts. And finally, I'll touch a little bit on social media, time permitting. And I'm putting them in that order because I think that's really the order of importance. The idea of technology is important to us for a lot of reasons, but primarily in this context, it's about communication, and that's kind of the nut of the technology issue for us and how it fits in with the regulatory framework that we have to operate. The Telephone Consumer Protection Act, I think, is the most important thing that I can talk about from a technology standpoint because of the liability that's there, the risk that's associated with a violation of this act. It's important to us from the standpoint of auto dialers are really an efficient means of contacting people. We can make lots and lots and lots of phone calls very efficiently, which saves money. When you connect that with the fact that we want to communicate with people, and cell phones are really the best way to do it these days from the standpoint of, you can see there if you're looking at the slide that there's more phones than people in the U.S. now, keeping in mind that you probably have 3 or 4 at your house and that your kids play with now, that they're not all active, but literally there's more phones than people, and more than half of the U.S. population has an active account. We also find our experience is that there's a significantly higher contact rate on cell phones than landlines, which common sense tells us makes sense simply because I can take my cell phone to work, I can take it with me, you know, to the neighborhood swimming pool, I can take it with me anywhere I go, so that I've got a better opportunity to answer it as opposed to my landline, if I still have one, which I do, by the way. My wife won't let me get rid of it, but I'd like to. So when you combine those two things together, that we can make efficient volumes of phone calls and we can have a higher contact rate, it seems like a great marriage from a collection standpoint. Unfortunately, the TCPA prohibits us from auto dialing cell phones for a collection purpose. And this is important to you if you have in-house collection efforts and you're using this technology. I'll also share with you that beyond collections, if you are using this technology for anything else, right? If there's solicitations, telemarketing, or anything else that you may or may not be involved in, this law isn't just about collections or debt collectors. Primarily, it's about telemarketers, and debt collection sort of gets pulled into it really within the confines of, are you making auto dials to cell phones? If you have consent from a borrower, you're allowed to make these phone calls, and I'm going to talk about consent in a minute. The reason this law is really important to us is the damages. It's a per violation statute, which means that every time you do something wrong, it's going to cost money, and that's a $500 per violation. And if you're doing it willfully, they're going to treble that, which I think is just a fancy way to say they're going to multiply it by 3, so that's up to $1,500. And I can tell you that that makes all of us in call centers nervous, because that's $500 at least per call. And so if you've got 50 calls, that's at least $25,000. And it doesn't matter that they didn't answer. It doesn't matter that they weren't home. It doesn't matter that you didn't leave a message. It's a per attempt situation. And so you can understand that if you're trying to get in touch with somebody over a period of time, it's very expensive. It's also going to be expensive if you're leaving pre-recorded messages, because that's necessarily an auto dial because there's not a human person involved. Likewise, if you're sending reminder text, a text is going to be considered a dial under this law. So when you're sending out payment reminders or you're sending out, pre-recorded reminders or anything, notices that are messages, and those calls are going to cell phones, you need to be concerned about the TCPA, because if you don't have your borrower's consent, it can get very expensive. The question of whether or not they can be made into a class action, well, that's still up in the air. I can tell you there's several courts that have come down and said no, and it's almost on a state issue. I know in the state of New York, I just saw something that says no class action in the state of New York. The real key issue here, I think, that we need to understand is what is an auto dialer. Originally, this law was designed as a telemarketing law. So the definition in the actual law talks about equipment that has the capacity to store or produce phone numbers to be called using a random or sequential number generator and to dial the numbers. And if you think about it, that's telemarketing, right? They don't know who you are, what your phone number is. They just want to dial 312-295-001. Then they want to dial 002, and so on until somebody answers the phone. That's not what we do when we want to communicate with our borrowers or your borrowers, right? We're calling from a list. We've got people, names, and phone numbers, and we put them into a database, and the telephony system dials them, probably based on some logic, I hope, but it's from a list. It's not just randomly generated or sequentially generated. Most of the dialing equipment that's sold commercially nowadays no longer has the ability to randomly or sequentially generate numbers, because they, of course, wanted to keep selling product and had to get out of the random sequential number generating business. Unfortunately for us, the next step, the FCC issued an opinion or an order that indicated that a predictive dialer is an auto dialer under this law. And I think that probably makes sense, because the idea behind the law is a whole lot of phone calls to cell phones where there may be a cost associated or maybe a nuisance is something that predictive dialer, the FCC found, causes a problem. It operates without human intervention. And that's the real, I think, part of this thing is when we start talking about whether it's an auto dialer, is are we doing something without human intervention? If you're not familiar, a predictive dialer is sort of a, to put it, I guess, in technical terms, it's a gizmo that's going to make a bunch of phone calls based on the number of agents you have available. It's just going to predict how many phone calls do I need to make to keep 20 people busy. And it's going to make 50 phone calls to try to keep those 20 people busy. The gizmo is going to guess how many more phone calls do I need to make 5 minutes later to keep these people busy when they're ready for their next call. And it's multiple phone lines and multiple phone calls regardless of how many agents you may have. Where that leaves us today is what's not an auto dialer. And I think we would all agree if you picked up a phone, if you've got keys on it, you push the buttons, that's sort of a manual dial. There's a case out there that talks in terms of a point and click, kind of in today's technology with a mouse, and that would be a manual dial, assuming it's not connected to a gizmo that randomly or sequentially or predictively dials. And finally, I think there's a whole lot of us out there that use what's called preview dialing or assisted dialing, where it's a combination of a gizmo that uses some intelligence to pick which number I should call or which account I should call a number on, but requires human intervention. The agent has to be involved. They've got to disconnect a call and push a button to launch the next call. And I'll share with you that I think that's pretty common, at least in the third-party agency side of things. I'm not sure about any of your institutions how much in-house collection work you're doing and using this technology, but I'm not aware that there's really any law out there that's settled that says that's a winner. And I think we're all hoping it is and waiting to see how that develops. But that seems to be right now where we are on auto dialers, is that if we've got some human intervention, we have a pretty good defense, or we're on fairly solid ground to make an argument that it's not an auto dialer. Okay, I guess the the next segment on this would really talk about some recent cases that came out which are making a lot of us feel uncomfortable, and that's this unintended recipient. There's two cases where the wrong person got the phone call and then sued under the TCPA. The first case was the roommate answered the other guy's phone, and the court said, well, you called the right number, just the wrong guy answered. That's not a violation. It's not about the recipient. The most recent case I've seen is a creditor got consent to call the cell phone, auto-dial that cell phone, and then, unfortunately, that number no longer belonged to that consumer, and it had been given to somebody else. And what's odd is the court put the burden on the agency to say, well, you're in a position to find out if he still has that phone number or not. And that's a very scary decision because there's really no directory assistance for cell phones. We can scrub and find out if it is a cell number, but there's not a directory assistance to know if they still have it. The court seems to suggest you would manually dial that number, and once you could confirm that it still belonged to that person, then you're okay to throw it back on the dialer. Another recent case that concerns me, and keep in mind I'm sitting in an office here outside of Chicago, Illinois. It's an Illinois appellate court decision. It's not a federal court decision, but an Illinois court recently put down a decision that TCPA damages were a penalty in nature, and as a result could not be insured against. And when you think about the huge risk that's involved in the damage scheme under the statute, and the fact that you may have insurance that you're paying for and it may not provide coverage, it's a little unsettling. And I don't know that that's going to be the law of the land anywhere else, but right now in Illinois there's an appellate court that found in favor of an insurance company. To wrap up TCPA, do's and don'ts: don't use an auto dialer to call cell numbers unless you have consent, and presumably you have the ability to demonstrate it. You can get consent a lot of ways, and one of the easiest is if the consumer or your borrower gives you that consent, and that can be they put it on the application, they talk to one of your customer service or agent people and give you that number.
And Mike, also, if you're using the financial responsibility statement or even a promissory note for student tuition, if you put a statement in there talking about that type of access, I think that would cover you under the law.
Yep, and that's, I guess, getting down a little bit further on the don't use an auto dialer unless you have consent. You should have a vendor to scrub your database, your phone numbers, and that needs to be updated fairly regularly, since we can all port cell phone numbers to landlines and vice versa. And the last one is attempt to get consent for you and those downstream of you when you create the loan. And again, what's important is not only to have something in the document, but that you've got a means systemically to track where you have consent, so you know when you have it and you don't. And in terms of, can you communicate that consent to your agencies downstream? For instance, that way the agency is in a position to run an auto dial campaign with cell phone numbers that have been designated with consent. Email, text messaging, and chat. And I think, again, we're really talking about more technology that's about how do I communicate with my borrowers. And when you think about today's population, people like to communicate in different ways. We like to contact people to talk about paying, and they want to talk in different ways. I think it's helpful to accommodate that. Our challenge is technology and the law, again, aren't always that friendly to us. The risks associated with text messaging, again, we're back to talking about TCPA because the text message is necessarily launched by an auto dialer. There's not really human intervention there. Unless you're manually sending text. I'll share with you that vendors are out there that are willing to take your money, and they have people that will push buttons to manually send these texts for you. Unfortunately, it's labor intense, and it creates the issue where a lot of these vendors are offshore, and that raises a whole other set of issues that we're always concerned about. Emails can carry the risk of third-party disclosure. I think the idea there is that you don't know if somebody's checking an email at work, if they have a shared account, or somebody else in their family may be involved in their email account. I also think once you get on the agency side of things, third-party, we have all these disclosure requirements. I think Wendy was talking about FODI, and when we have to add what makes a voicemail 40 seconds long, we have to start adding those things to text or emails, they become problematic. I think the silver bullet, if there is one, really is consent. I think that'll go a long way to help avoiding some issues. If you can incorporate consent, and again, you can do this in your loan origination documents or anywhere along the way, consent to communicate with your borrower via email, via text messaging, via other means as they come out, because I'm sure there'll be other ones. And again, the ability to trap that consent systemically so you know when you have it and you know when you don't have it, and the ability to communicate that consent to your third-party agencies if you use them so they have the ability to use it. You know, the goal, of course, is not to break the rules or to create risk. Really, we want to communicate with people to talk about working out the debt. And if we can get consent, it can be a win-win, because there are a whole lot of people that would prefer to get an email, that would prefer to chat online, that would prefer to communicate sort of in what most of us would think are non-traditional ways. Can I chat with borrowers? Again, consent goes a long way to help, and typically chat would be, you go to, you know, a borrower would come to your website where presumably you've got a whole bunch of notices and disclaimers which set you up for permission to chat. Obviously, everything in today's world needs to be secure when you're talking about consumer data and information. Record retention concerns come up for all these technologies, emails, text, chatting, because it's always funny when you kind of mess around with somebody's email and change it a little bit and send it back to them, and they think you kind of play a joke that maybe they said something else. But if a borrower can get that email, text, or chat and change it up a little bit, if you don't have a record of what was actually sent, you may have a problem. Okay, last section. I realize we're going here quickly as we come towards the end of our time. Why social media and collections? I think we can probably all answer that. Most of us probably talking and listening here today have a Facebook account. Maybe you tweet or twit, or maybe you're LinkedIn or not, but the idea is there's a whole lot of people using these things. From our standpoint of collections and recovery, it's all about information, and primarily where these tools are helpful, at least right now, are really in tracing. Let's find people, let's find out an ability to pay, and really in a nutshell, I think it's okay to look. When you go on Facebook and you look and you get some information, if somebody doesn't have privacy settings, you can look. Same thing if somebody's got a Twitter account with no privacy settings, so when they post something, it's available to the public. Go look. It's kind of like Googling somebody, and you can get some information that's out there for the public. Beyond that, I think that you're asking for trouble. To try to communicate through one of these vehicles, you're really going to bump into a whole lot of, again, on the agency side, disclosure requirements, and in terms of what you've got to notify them that it's an attempt to collect a debt and meaningful disclosure of your identity. I think you'll also run into some state law disclosures about what text does and doesn't appear in that communication. And I think, as always, you have to be concerned about security and third-party disclosure when you post something. I'll share with you, my wife, she does something or other on Facebook, and then she doesn't know why, but all of a sudden the whole world knows that she was reading the latest, you know, National Enquirer article about Sean Penn or something. It just posts, and she's not sure how to turn it off. But if you do want to communicate through one of these social media networks, I think you need to be very, very careful. Obviously, if you go to the next step and you are going to misrepresent who you are or why you're friending or tweeting or following, you're asking for problems, because all of these sites have some component of, I've got to friend you, I've got to invite you to follow, and something like that. And the last comment I will make, and I know that I'm passed out of time, there's some privacy issues here, and I know as a lender you've got to be concerned about fair credit and some discrimination issues, especially if in this setting, if down the road there may be refinancing or something, if you're going to be involved with more lending, that are you going to learn something about one of these folks that you really don't want to know from a lending standpoint? Thanks for your patience.
Thank you, Mike. We have just a minute. We have a couple of brief questions. Any questions that we don't get to before the end of the webinar, when the email goes out to you the next day or so, we'll have the answer about the recording. We'll have the answers to those questions for you. One question, what does the CFPB stand for? Again, Consumer Finance Protection Board. I'd like to open this next question up for Mike and Wendy. For in-house first-party collectors, does meaningful disclosure and/or mini Miranda apply?
Not under the Fair Debt Collection Practices Act, but some state laws apply the same rules to first party as they do to third party. And David, as you had mentioned earlier, there's the Privacy Act as well as some of the other regulations that may apply. So you'll want to make sure you look closely at those.
And Beverly, my comment there would be that if you're applying other facets of the FDCPA for your in-house collections, you may carry that forward even though you don't have to as a first party. The next question, is there a preferred text to be added to financial responsibility agreements that will allow consent for the numerous means of communicating?
Is there bulletproof language or a silver bullet? No, but I think that, and again, you can craft some language that when we go back to transparency on collection costs and fees, I think you should be transparent and be specific that you want consent for you, agents, representatives, collectors, attorneys, anybody that you may have downstream of you, and spell out, we may communicate with you via email, text, cell phone. We may use pre-recorded messages. I would argue on that being conservative and going in more detail is better than not.
I agree, Michael, especially since we don't have a whole lot of answers on that right now. I would, however, be careful because what the Federal Communication Commission as well as the Federal Trade Commission have said about getting consent up front is that you want to be very careful that it does not appear either it doesn't give the appearance in either actuality or just the appearance of you making whatever product, service, loan, etc. that you are offering, that it is not contingent on them giving that consent. If you're going to not give them a loan because they didn't consent to receiving auto-dialed phone calls on their cell phone, you can't say, well, then sorry, we're not going to give you this loan. They can't be contingent on each other, so I would just be very careful about that.
Final question. If a student during the exit counseling process gives you their cell phone number as a point of contact and then defaults, does that give permission to use that cell phone number?
I'm sorry, can you say that again? When do we get the cell phone number?
We get that during the counseling process when the student graduates or leaves school.
I'm not real comfortable with that. I know that the consent, the FCC talks about consent. They've given you the number in connection with the debt, and in terms of, hey, it's on my application, that's one thing. They called in to ask about their payments, and they gave you that number. But if we're talking counseling before I graduate, that's not. I don't see that as related necessarily to the debt. That might be related to, are you going to help me find a job when I get out of here?
Mm-hmm. Yeah, I agree with that because the consent has to be prior express consent. Do they know that by giving you that phone number as that point of contact that what they're expressly consenting to? The consent in this circumstance can be verbal, but you want to make sure that they know what it is that they're agreeing to.
Yeah, I'm just not sure that's in connection with the debt. It seems tangentially related.
Hey.
Yep, I agree.
Thank you very much. Michael and Wendy, thank you very much for your information. I think it's been very valuable. Denny, I'm going to give you the last word and thank everybody first for their participation today. Denny, the last word is yours.
Just remember there's two important dates. One in September, that's the 27th of September. That's our next webinar dealing with asking tough questions. And December 6th, and that's our Tuition AR panel, and we'll be exploring all kinds of really neat issues and questions related to Tuition AR.
We'll leave the Q&A and chat boxes open for just a couple minutes, and again, thank everybody for their participation today.
Yeah, I just want to say one more thing. At the conclusion of the webinar, as you close down WebEx, there'll be a series of 4 or 5 questions, brief questions. If you can answer those questions, we'd greatly appreciate it. It helps us for preparing future webinars. So, again, I appreciate everyone's participation, and I thought it went really well. Thanks.
Thank you.